We have a quorum. I call the meeting to order. Item number 1, information paper issued since last meeting. The Secretariat issued 1 information paper. You will find the title of the paper under item number 1. Any questions? No. Item 2, items for discussion at the next meeting. In the next meeting, which will take place in January next year, the date is 28th of January 2013 at 10:45 in the morning. The CDB, the THB, that is the Commerce and Economic Development Bureau, the Transport and Housing Bureau, and the Environment Bureau will send their secretaries to give us a policy briefing on the policy address of the Chief Executive for 2012 and 13. Do you have any issues that you would like to raise to the Secretary? No? Item 3, implementation of the Maritime Labour Convention 2006 in Hong Kong. First of all, let me welcome the administration. We have with us Mr. Yao Shengmu, Under Secretary, Ms. Jenny Chan, Principal Assistant Secretary for Transport and Housing, Mr. Cheng Yong-ming, Chief Marine Accident Investigation and Shipping Security Policy, Marine Department, and Mr. Wang Sai-fat, General Manager, Shipping Industry and Seafarers, Marine Department. Perhaps I will ask the Under Secretary to take us through the paper first. Thank you. The objective of this item is to brief members about the implementation of Maritime Labour Convention 2006 and its subsidiary legislations. Hong Kong is the biggest ship flag administration, and we have been actively implementing relevant requirements under the international laws. In 2006, the International Labour Organization endorsed the MLC, the Maritime Labour Convention 2006. Apart from consolidating and updating the existing requirements for the employment of seafarers, more comprehensive minimum standards for the working conditions of seafarers will come into place. The convention will come into operation on the 20th of August next year. The requirements will be put in place through subsidiary legislation. We have consulted ship owners and seafarers, and we have drafted the relevant legislative amendments. We have to amend Cap 478, that is the Merchant Shipping Ordinance and relevant Merchant Shipping Seafarers Ordinance and the relevant regulations. There will be a new forensic inspection and also enforcement mechanism. Hong Kong registered ocean-going ships over 500 gross tonnage will have to display we have to maintain a declaration of maritime labour compliance and a maritime labour certificate certifying the working conditions and living conditions of seafarers on the ship comply with the MLC requirements in 14 areas. They are in relation to medical certification and relevant procedures and safety issues. This is to ensure that all the requirements are complied with and to conduct investigations. The Marine Department may board vessels of contracting parties, and by then I mean vessels in Hong Kong waters, to carry out the inspection to ensure compliance. As a result, the living and working condition of seafarers will be improved, and I am happy to take questions from members. Thank you, Under Secretary. We have with us Mr. Tan Ka-piu, Lee Cha-gan, and Frankie Yik. We have quite a lot of items on the agenda today, and there is also an item that is close to your hearts, and that is the last item in the agenda. So for this round 4 minutes for each member. Mr. Tan Kap-yu. There seems to be a lot of grand measures in place, but I would like to get some clarification. In relation to page 4, that is, under specific conditions, the seafarers may ask for repatriation to their place of origin without paying for their expenses. What does that mean? By specific circumstances, do you mean the seafarers being fired? Can we get more information in this regard? Will there be dedicated consultation in this regard? And also in relation to complaint handling mechanism. If there is one set up on board, and if the complaint cannot be resolved on board, and the vessel happened in Hong Kong waters, what is the role played by Hong Kong? If the vessel is due to leave port, does it have to stay in Hong Kong waters as a result? How do you protect the complainant? There are also some inadequacies that I would like to cover. International Labour Organization in relation to seafarers. There are two rights that are not covered by this. First, retirement protection. Well, one of the areas of the requirement is medical attention on board. But there is something missing, which is retirement protection. If a seafarer employed by a Hong Kong ship owner being on board on an ocean-going ship, he does not have any retirement protection. Would you like to, perhaps we will let the administration answer your 3 questions. There is also one thing, a right of assembly and also collective bargaining is also stipulated under the International Labour Organization, but is absent here. In relation to point 1, under specific circumstances, seafarers are entitled to request for repatriation to their place of origin without paying for the expenses. These are specific circumstances, that is, when they're injured, when they have fallen ill, or there are accidents, and or the ship owner has gone bankrupt, or a vessel has gone into a war zone, and the seafarer is unwilling to be involved. Second point, in relation to complaint handling mechanism. The complainant may lodge a complaint to the master of the vessel, and if they're in Hong Kong, they may lodge the complaint with the Marine Department, who will take it up. And the two rights, collective bargaining and also retirement protection. We are fulfilling the minimum requirements under the International Labour Organization. What they ask for is to respect the right of collective bargaining. There is no requirement for legislation. We have conformed with the requirements in relation to the International Convention in this regard. Yes, we're aware that there are such rights in place, but they will have to be handled in accordance with the respective jurisdiction. Mr. Lee Chuk-yan, I want to know about the coverage. There may be some people who are left out. Say, for example, the Shantak or Hong Kong Macau, because they are not covered by local employees' legislation. Will this new ordinance cover them? Because at the moment they are in the void. I remember that about a decade ago, they were nearly covered by labor protection legislation, but somehow they were left out. I find it really regrettable. A lot of Hong Kong people are employed to go between Hong Kong and Macau, and in comparison, there are less when it comes to ocean-going vessels. So will they be covered, Secretary? This legislative amendment is in relation to ocean-going ships. These vessels will leave port for quite a long time, not just a day or two. And these are requirements in relation to working, living conditions, the onboard medical care, and onboard recreational facilities as well. Mr. Lee mentioned about seafarers working between Hong Kong and Macau. And at the moment, they are protected by the Merchant Shipping Seafarers Ordnance Cap 478, and there are requirements in relation to working hours and also food and catering. But they are not covered by local labor legislation, not severance pay or anything, and this convention doesn't cover them. So this issue remains unresolved.
And these are the most numerous in terms of seafarers. However, they are left completely unprotected. Now, since you are amending this ordinance anyway, can you extend the coverage to them? Yes. Mr. Lee is concerned that this international ordinance does not cover the Hong Kong-Macau ferries. Now, for vessels operating in Hong Kong waters, this should be applicable. For vessels which actually operate between Hong Kong and Macau, then it is not. Well, according to my knowledge, the employment ordinance actually does not cover this. Well, in fact, for local vessels, there are, and seafarers in these local vessels, in fact, their employment coverage is different from the average employers, and I would say that in fact they are, in terms of conditions, perhaps better off than the average seafarer. Well, we can delve in that further. However, what we are talking about is really long-haul seafaring vessels, and we are really abiding by the international ordinance in the treatment of these seafarers. Now, as for this proposed amendment, the Ship Owners Association of Hong Kong is in support of it, because this will allow Hong Kong to be in compliant with the international ordinance, and this would help in the Hong Kong status as a shipping center. Now, next year in August 28th, this will come into effect. I do not know whether the Hong Kong SAR is able to complete the amendments required. And if not, then the concern from ship owners is that, well, the ships maybe of these Hong Kong ship owners may have to be detained for investigations, and they are duly concerned. So we would want to ask the question whether the Hong Kong SAR would be able to comply within the time of enforcement. And if it cannot, how can we solve or help decrease some of the troubles that the ship owners may actually see? Now, and another point concerning the review, the 5-year review, I would like to know, actually in the paper it is also mentioned in the second year and the third year, the review, would it be perhaps more straightforward than the initial one? Well, for Mr. Yip's question, there are actually two parts to it. First of all, we will put in all efforts and try our best to put this into enforcement as soon as possible. We will start with the drafting right after this meeting and complete the process within this legislative year. There is a possibility, as Mr. Yip had mentioned, there is that possibility of not being able to complete the work within the time, and our preparation is for some associations, which is vessels-related associations, allowing the vessels which abide by the ordinance to have a temporary certification to certify that the vessels actually do comply with the international ordinance so that they can continue to operate in the waters. Now, as for the review, the paper actually has mentioned that, and that is the requirements are basically the same as a requirement for any reviews. Well, actually, Mr. Yip asked a question about some necessary amendments. Well, the Ship Owners Association is of the opinion that since the license is for 5 years, then perhaps the review can be shorter. Well, same with factories obtaining ISO certification. Actually, the annual review would be more straightforward and taking less time, the original round of certification inspection. So that is the spirit of my question. Can it be more straightforward in the reviews? Well, in fact, we are following the ordinance requirements. If we see that there is room in terms of our execution, that there can be convenience provided to the ship owners, of course, we will afford that. However, we will abide fully to the procedures prescribed. Well, Ship Owners Association may want to come up with areas or procedures which can be streamlined for subsequent reviews. Yes, we will be happy to hear from the Ship Owners Association. Mr. Yu, please. Now, in the background paper, it says that we are number 4 in terms of tonnage. And we are also one of the most reputable ship flag administrations in the world. So that is to say, we are pretty good in our records in this regard. Now, in terms of enforcement, I would like to know whether there had been any questions concerning regulations and enforcement of ordinance. Now, we have some new amendments. I would like to know from the government what are some of the procedures to ensure that the ship owners do comply in the future. Well, Mr. Chairman, actually, in administering our registered ships in Hong Kong, even though it is over 2,000 strong, our past record had been good. From different ports of call and the reports from them, our records have been good. And we have not met with major issues, but of course, from time to time, we may have certain cases where there may be firefighting equipment and oil spills equipment, etc., which may be deficient. And once we get hold of this kind of information, the MD would follow up with the ship owners to make good the situation before the vessels set sail again. What about going forward after these amendments? Well, with the new amendments and the convention, there is one recommendation therein, and that is there will be a new regulation whereby the MD would be able to send investigators or inspectors to go on the boats and make inspections. Well, the ship owners, as long as they can allow this, they will be certified, and wherever the vessels are in the world, whatever port it is situated in, that kind of certification can be given. So that is to say the ship owners will have the responsibility as well as the right. Well, actually, we devolve the responsibility to the relevant party, and they can carry out the inspection. Well, I think we are all in agreement with the recommendation concerning the Maritime Labour Convention. Yes, thank you very much, administration. We now go on to the next agenda item number 4, draft enforcement guidelines and other enforcement matters in respect of the fair trading provisions in the Trade Description Ordinance. I would like to invite the relevant officers and representatives of the administration, Mr. Cheng Meng-ching and Commissioner of Customs and Excise, Mrs. Alice Chung Chiu Hoi-yu, Deputy Secretary for Commerce and Economic Development, Mr. Ha Yong-kyun, Deputy Director General Telecommunications Office of Communications Authority, Mr. Chan Chi-keung, Head of Trade Controls, Customs and Excise Department, Mr. Sander Jerksing Tat, Assistant Director, Office of Communications Authority, Mr. Lam Po Chun, Head of Trade Descriptions Ordinance Special Planning Group, Customs and Excise Department. Yes, they are proceeding over to this room. We welcome members of the administration. Now, if you are quite prepared, please do bring us through the paper. Mr. Chairman, Mr. Chung, well, I would like to thank the economic panel, or the panel on economic development, to give us this opportunity to describe the Trade Description and Fair Trade Practices Amendment Ordinance 2012 Draft Enforcement Guidelines and other enforcement-related matters. In fact, on the 17th of June, this ordinance had been passed by the LegCo with a number of related areas which are very important in enhancing the protection of consumers in Hong Kong. And in different forums, I have repeated the following points, one of which is that the realm of coverage includes service, apart from commodities and products. So where there are purchases by Hong Kong consumers for products as well as services, it would come under this ordinance. And secondly, for false trade descriptions, there will be a more forward-looking and more general or conclusive description for that. And also, we have certain types of trade practices, such as misleading omissions, aggressive commercial practices, bait advertising, bait and switch, and false trade descriptions of services, as well as wrongly accepting payment are all included. And this will give us a more diversified range of tools, apart from warnings, written warnings, and also other enforcement methods. We will also be able to, under certain circumstances, have the traders also reach a certain agreement with the enforcement authority so that it will refrain from the activities that run foul of the ordinance, so that this will be more easily and also more financially expediently resolved for stamping out this kind of behavior. Now, in the discussions in the LegCo, Chairman, you are most cognizant of that. We have included a number of new amendments concerning enforcement and also the crimes concerning unfair trade practices. We have also mentioned that we will educate and publicize for the sake of the citizens of Hong Kong, and also to discourage any further such behavior from the commercial side. And therefore, we have come up with certain publicity campaigns, and also in terms of to promulgate the procedures and the priorities, and also the targets, and also the objectives, and also some of the examples of such contraventions which are included. In the 6 months from October 7th to January 17th, we will have this period whereby we will further enhance this directive and guideline, and hopefully, and at the time of enforcement with this draft guideline, enforcement guideline in place, we will be able to do an even better job. Mr. Kwok Pui Fan, Mr. Chairman Kwan. Now, 4 minutes each, because we have a number of agenda items, and we have one which is of quite a bit of concern at the very end of the agenda, so we would need to be respectful of the time. Well, Mr. Chairman, I think this is a good thing, this trade descriptions ordinance for the commercial world as well as for consumers. However, we did not receive the paper until late, and I think a lot of the commercial associations and business associations are really not in the know. I think the content is very much provided and in detail, but I think we need some publicity. We do not want people to run foul of the law because of ignorance.
I hope information can be disseminated to trade associations and individual traders. Different traders have different aspirations. You said there will be consultations, 5 sessions, one for the public and the rest for the trade. I hope that there can be dedicated consultation sessions for individual trades, say for example travel agencies and sales of goods and services. They may like to get some specific answers. Is the 6-week consultation period sufficient? Can it be extended? Will there be specific consultation sessions for individual traders? Thank you. Commissioner, first of all, I thank Mr. Yeo for recognizing the effectiveness of the trade descriptions ordinance, because this further enhances protection to consumers. Consultation, first of all, before the ordinance was passed by the LegCo, we have already set up a liaison mechanism with traders. We have trade associations and individual bodies on our list. They have been categorized by the nature of their trade. When we conducted the consultation before the ordinance was passed, there are altogether 9 consultation sessions, 6 of which will be for traders. And out of the 6 sessions, 3 of them are for major trade associations, organizations, for them to dissemination information for us. Whereas the remaining 3, they are for organizations and associations that are not covered. We sent out invitation by types of trade. There are also 2 sessions for public. Say, for example, there are individual traders, there are SMEs. They may want to express their personal opinion in a public consultation. And there are also consultation sessions for traders. We think that we can achieve what we want to achieve. All consultation documents are available on our websites. Hard copies are available in district offices and also consumer advisory centers under the Consumer Council. So the information is easily accessible. What about consultation sessions to individual types of trade? So if some practitioners, stakeholders, traders of a certain type would like to ask you to give them a briefing session, would you do it? Of course, we aim at an extensive consultation. So we would like to hear from trade associations or traders, and we will be happy to do that. Is it done through custom and excise or the commerce and economic development? Well, there are two teams. We will send representatives to attend consultation sessions. Next, Ms. Elizabeth Quat. I see that there is this timeshare and also the long-term holiday package, and also then also there's something about the cold and cooling period. But in the end, the administration did not incorporate cooling period. But we've received a lot of complaints related to, say, for example, membership of yoga centers or some travel clubs. If we do not have cooling period, the protection afforded to consumers will not be comprehensive. What about membership of beauty salons and the problems they have caused? These have not been resolved. So are there any plans in relation to the incorporation of cooling period? We would like to see cooling period and advance payment being covered under the Trade Descriptions Ordinance. Cooling off period. Well, there are already provisions dealing with wrongly accepting payment. If a trader asks consumers to participate in a transaction and accepted payment, but if the service or the product is not up to the expectation of the consumer, or there is a big difference, there are already provisions under the ordinance dealing with them. I understand that in the Bills Committee there was a detailed discussion in relation to the cooling off period. And it's not just about the effectiveness of the cooling off period. They've also taken into consideration various operational difficulties. It was abundantly debated. And these include the types of goods and services. Is it the best arrangement? Should it be extended to other products and services? What about transactions involving a small amount? Should such arrangement be triggered for a small amount, a small sum? What if the consumer would like to start using the service or the product immediately? And when that happens, can the traders get back an appropriate sum of administration fees? How will it change consumer behavior? Will the administrative cost be transferred to consumers? In the Bills Committee, it was decided that since there is already some consensus and there are expectations to increase consumer protection, so areas where there is consensus will be taken forward first. And we keep an open mind when it comes to introduction of cooling off period. We would like to first see how the operation of these provisions first. And we would also like to educate the trade and also to, the consumers. We hope that there will be more objective discussions. I hope the administration will study it and not just leave it to the back burner. Mr. Chang Han Ban. I also would like to talk about cooling off period. Say, for example, when it comes to unfair trade practices, say bait and switch, bait advertising, or aggressive commercial practices. By bait, what do you mean by bait? Aggressive. How do you define aggressive? We hope that there can be a cooling off period, because that is the best way to protect consumers. The consumer, after leaving the venue, may wake up to the fact that he was under duress at that time. And we see that the Custom and Excise and also the Communications Authority and the Consumer Council. But very often, consumers, when encountering problems, will first make a report to the police. Are there any cooperation arrangements with the police for case referral and follow-up? Will the police handle such cases? Mr. Chang, we have close liaison with the police, in particular in relation to tourist spots. There is already a mechanism in place and it's proved to be effective. We have a communication mechanism with different police districts, and at designated times we mount joint operations with the police, targeting unfair trade practices that target mainland visitors or overseas visitors. So the mechanism in place is effective. You mentioned about Consumer Council and the Communications Authority, the OFCA, the Office of the Communications Authority. A Consumer Council mainly deals with mediation. If a consumer would like to get a refund, the Consumer Council will be able to help. But if the Council is of the view that there are elements in the case that suggests a possible breach of existing laws, then they may want to refer to the case. And we can't rule out the possibility of more complaints or reports made. So we have a plan with the Consumer Council to have an electronic information exchange platform to enhance efficiency. And in relation to the OFCA, the Office of the Communications Authority, we have concurrent jurisdiction under the Ordnance. And we're allowed to formulate a memorandum of understanding for the delineation of work and how we carry out our respective investigation. And the provisions will clearly set out individual areas, and the information will be disseminated later. What about difficulties in proving the case? Is there any more information supplied? This is something new. All I can say is that we will try. From what we've learned, say from the press, or from the media and cases we have dealt with, the tactics used is not such that evidence that we cannot obtain evidence. Say, for example, it can be physical, it can be a certain form of false imprisonment, or within a short time, different people will coerce the victim to do the same thing or to withhold a person's identity document. When we think that we can do it in terms of enforcement. Mr. Ronnie Tong. I'm also concerned about enforcement. There are two enforcement agencies here, and there may be problems. As we've learned from the Lehman Brothers incident, the Hong Kong MA and the SFC have different approaches when it comes to enforcement, and it has caused a controversy. So when it comes to consumer rights protection, is it better to be handled by one single enforcement agency? My understanding that the scope under the OFCA is more narrow, whereas that for the CNE department is wider. So why can't there be a better coordination? The second point, the current proposal does not cover disclosure of information of people who have breached the law or who have committed non-compliance. But very often, well, at the moment, we can only deal with it, and nobody will know about their information. And if you disclose that information, the deterrent effect is much higher than a fine of several $100s or a few $1,000s. So would you consider this approach? The Consumer Council in the past has tried to do it this way. Say, for example, in an open manner, disclose information of shops engaging in such tactics, and it seems to be quite effective.
Yes, concerning the division of labor, we are very clear about it, and I think, relatively speaking, it is clear, the division of labor. Our line of thinking is that where there are telecoms related and telecommunications ordinance related licensees, and if the service provided within the license, then it would be the Office of Telecommunications. However, if it is not these activities but other commercial activities, then it would come under the Trade Descriptions Ordinance. Now, what if there are a crossover? That is to say, the contraventions are crossovers, then I would think that it really will still be the Customs and Excise Department which will take the lead in the enforcement. In terms of undercover investigations or inspections and raids, etc., it really is still the Customs and Excise Department which is more experienced, and therefore it should take the lead. But on the other hand, the Telecommunications Office would provide the technical support still, because there may be certain technical issues which the Customs and Excise Department would need certain support from the office. Now, as for exposing the names of the shops, in fact, we have provided flexibility or more flexibility to the Customs and Excise Department in the past. Before the prosecution, any exposition would be very limited. But in the future, with a new mechanism, within the agreement, the content of the agreement can be made public. Now, this agreement has to be agreed by the shops or the traders concerned. But if there are recalcitrant ones and it takes time to bring them in, and you can't basically do it unilaterally, the fact that they are willing to sign that agreement would mean that they are at least repentant. But I'm worried about those which are completely recalcitrant, completely unrepentant. Can you consider those? Yes, can you please consider that point, Mr. Chair? Do you have any supplements? Well, yes. Actually, sometimes we will have to balance among various considerations. First of all, for first-time offences, especially, we have to go to the length of the procedures before we know what the outcome would be for certain contraventions. However, there are others which are recalcitrant, and that is a clear inclination that this is repeated behavior. Then we actually do expose the shops, and actually through the Consumer Council it has already been done consistently. Well, actually, I see that there are a few departments involved in the enforcement. For telecommunications sector, in fact, there had already been views made that even before the legislation was passed, that there may be enforcement issues. I think Mr. Yu had already mentioned the same issue, and that is, will there be sector-specific discussions? I think it is necessary, especially for telecommunications sector, because there are at least two different departments responsible for supervision and enforcement, and therefore my question is, concerning these sectors, our industries, can we have certain meetings with them or consultations with them, so that at least meetings, so that the people within the industry or sectors can ask questions, so that they will know what the details are? That's very true, Mr. Chairman. As mentioned just now, for this enforcement guidelines, apart from public education, we also have to have sufficient publicity for the sectors and industries concerned. And exactly on telecommunication sector, it being a more unique sector with a lot of employees in this sector, we have a special arrangement for them. Perhaps my colleague can talk about that at length later. And if there are certain trade bodies which we believe is representative and represent a sufficient number of bodies and entities, and we can definitely conduct a meeting with them. We are very willing to do so. Mr. Wu Chi-wei, concerning this ordinance, the core issue is that all along we have been talking about a cool-off period, and that was actually taken out in the last round of discussions. Now, I do not know whether someone has already asked this question, but I would like to know about this cooling-off period, where, how, and when it will be put back into the trade descriptions ordinance. In fact, there was already a view that the cool-off period should be incorporated into the ordinance. However, because of enforcement issues or execution issues, it was taken out. I'd like to know whether there's a timeline or a roadmap for the inclusion of the same. Now, and another point, there is a possibility of prosecution for such trade practices in the future. And I am happy to see that. But in coming up with the guidelines for enforcement, I do not know whether there will be very detailed guidelines for the relevant sectors to know what exactly constitutes a contravention to the ordinance. Because very often in the market, we see old folks, and we see this very often. They have been unduly and by tricks, they have been disallowed to leave the shops, and they were under coercion made to buy very expensive products. I would like to know from the government whether there will be this cooling off period which will be incorporated as part of the ordinance in the future, and also some of the specific enforcement procedures, whether there will be another detailed guidelines for the public and for the sectors concerned. Well, actually, we have asked the question and answered the question about the cooling off period, but perhaps Mr. Chung would like to do that again. Well, actually, there are 3 questions. The first one about cooling off period. I'll be succinct because we have already answered that question. We are open in our stance. As mentioned, we do not have a consensus, and there are certain areas where we have not considered in full. But in terms of timing, I think we should enforce what is already consensual so that the consumers can benefit. And in fact, I would like to thank the members here for providing that kind of consensus and support. And we have come to this point in our legislation. I thank you for that. Now, secondly, for the consumers' protection in the enforcement, we will be meeting with certain situations, and some are difficulties. And we would want to be able to learn from that and provide further protection to the consumers, whether it be cooling off periods or whatever. We will be going through the relevant departments and come back for further consideration. Now, concerning the third question, this ordinance is new in Hong Kong, but in many countries, in fact, it's been ongoing for a number of years or for a period of time. For example, we have referred to the Australian experience and UK experience in their relevant ordinance, and there are case laws, and we do refer to them. And with the DFJ, we do refer to these precedents, and it is very helpful. So do not be worried about that. And concerning the enforcement guidelines, as you can see, we have included a number of examples there. We can never be exhaustive, but I would like to point out that these are not legally binding, but rather they are examples, and we would be adding to them to make them more comprehensive in the future. Yes, concerning the amendment of the ordinance, I think after the amendments it is indeed more comprehensive in its coverage, and there will be enforcement guidelines coming out in the future. And I also know that the Customs and Excise Department is doing a lot of the work related to it. Some people think that you only stop narcotics import at the borders, etc. But in fact, you have also spot checks, etc., concerning areas in the ordinance. Now, for enforcement of the ordinance, I would like to know from the department how you train up your frontline officers. For any new ordinance, I'm sure, would be different from what you're used to. I would like to know when you will commence with such training programs. And also, for this ordinance, you'll be working together with the the Communications Authority, the CA. So, in the future, would the CNED be responsible for the enforcement of the ordinance, and there would not be any clashes with the other authority? I hope that the enforcement would be smooth. Now, concerning spot checks and also prosecutions, etc., there will have to be a clear and proper legal procedure. It is, of course, not that any apprehensions can be done loosely, and it will not result in a successful prosecution. And I'm sure you will have training in this regard as well in your training program. Would it not be so? Mr. Chang, can you clarify those points, please? Yes, you have asked a lot of questions concerning, well, inside the trade, so to speak. First of all, concerning the amendments and the contraventions, indeed they are new. However, the Trade Descriptions Ordinance itself is not new, and there's been protection afforded for a number of years. But as I have mentioned, we are adding in services as well. And in fact, we are carrying out this work. But as mentioned by the chairman just now, the nature may be different in the future. First of all, on training. It is not that we have just started with the training now, but rather since the passing of the legislation, we have already started doing so. We have sent our officers to the UK, to Australia, to the enforcement bodies to receive training. And also, we have gathered information concerning difficulties of enforcement and come back for further training of officers. But because of financial constraints, and we would want to maximize our resources, we would want to have an Australian expert come to Hong Kong and stay for a couple of days in Hong Kong so that there will be compressed and intensive training so that more of our officers would benefit. And further, Mr. Chairman, you have mentioned just now concerning prosecutions, it is quite different from the work mentioned. And we have a working relationship with the DOJ for some of the cases in the media that we already see. We may be using them as test cases or as examples that we can work on together. Now, as for the CA, because they have never had any enforcement for criminal offences, so we will be training up, helping to train up communications authority personnel as well. Now, you talked about, Mr. Chairman, procedures. If I can go back to my original answer, and that is we have a conversation and working relationship with the DOJ, and we will come up with certain procedures which we can follow in the future cases. Any other questions? We would like to thank Mr. Chan. Now, the questions were very clear from the members. If you can follow up after you go back, we would like to thank you again for coming to the meeting, you and your team. Thank you. And next is agenda item number 5, proposed creation of a permanent post of Judge of Court of First Instance, JSPS point 16, and a permanent post of Deputy Registrar, High Court, JSPS point 13.
官員入嚟。
Can we invite the administration to come in?
出席今次嘅會議。
We have Ms. Carol Yuen, Deputy Secretary for Commerce and Economic Development, Commerce and Industry, Mr. Raymond Wu, Principal Assistant Secretary for Commerce and Economic Development, Mr. Arthur Ng, Deputy Judiciary Administrator, and Ms. Wendy Cheung, Assistant Judiciary Administrator. Who is to take us through the paper? Ms. Yuen? In June this year, the legislature passed the Competition Ordinance, which stipulates a legal framework to prohibit anti-competitive conduct in all sectors to ensure that Hong Kong will have a sustainable competitive environment. The ordinance provides for a judicial enforcement model which separates powers of investigation, prosecution and adjudication of breaches of the rules among different authorities. A competition commission will be established as an independent statutory body to investigate such cases, and the tribunal under the judiciary will be set up to adjudicate on competition cases brought by the Commission, follow on private actions, alleged contravention of a conduct rule, etc. The Chief Executive, every CFI judge will be a member of the tribunal. The chief executive shall, on the recommendations of the judicial officers' recommendation commission, appoint 2 of the members of the tribunal to be the president and deputy president of the tribunal for a term of at least 3 years, but not more than 5 years. The ordinance also provides that every registrar, senior deputy registrar, and deputy registrar of the High Court holds the corresponding office or position in the tribunal. The president will play an important role, and it will also advise the Chief Justice and Chief Judge of the High Court on the development and implementation of policies and practices in relation to the tribunal. The registrar will also support the making of rules regulating and prescribing the practice and procedure to be followed in the tribunal, assist the registrar in listing and case management, administering the suitors' fund of the tribunal, etc. We have additional heavy workload. Apart from the president and the deputy president, other CFI judges may also be involved in the hearing of tribunal cases from time to time. Similarly, the registrar, other senior deputy registrar, and or deputy registrars of the High Court will work together with a dedicated deputy registrar for the tribunal work. The judiciary's assessment is that they will require 2 additional judicial posts, namely 1 CFI judge and 1 deputy registrar. And we propose that starting from the 1st of April 2013, these 2 posts will be created for the preparatory work for the establishment of the tribunal. And on the 28th of November 2012, a commencement notice was introduced at the Legislative Council in order to commence the provisions related to the tribunal on the 1st August 2013. This allows time for the creation of the caption posts and the appointment process for the president and deputy president for the tribunal. With members' endorsement, we reckon that at the end of January next year, we will seek support from the establishment subcommittee for the creation of supporting posts. Just now, the subcommittee has I would like to say that the Chief Executive in Council has recently agreed with the adjustment of pay for judges and judicial officers. And the pay increase is subject to the approval by the Finance Committee. So the pay of the President and the Deputy President and the relevant posts will be updated when we submit the paper to the Establishment Subcommittee. This is my presentation. I'll be happy to take questions. Thank you. We have Mr. Ronnie Tong. Mr. Tong, I'm very disappointed with this proposal. In our discussion and passing of the competition ordinance, we expected to have a senior or experienced judge to preside the tribunal, but now we hear that there will be a new judge. It is not an easy task to enforce the relevant provisions in the ordinance. The cases might be complicated. We need an experienced judge because it will be more appropriate than a new one. The judge will be the gatekeeper for not just the business sector but for consumers as well. So why don't we just create a judicial post and for the Chief Justice to appoint a person to preside the tribunal. Say, for example, in the insider dealings tribunal, the approach is for the Chief Justice to appoint a senior judge to be the judge in the insider dealing tribunal. And if need be, there can be another High Court judge to dealing with easier tasks to accumulate experience. I do think that the current approach is not very suitable. And in relation to the registrar, I don't have much comment on that because they will not deal directly with cases. But I do think it's problematic to have a new judge who's never dealt with any cases to be a president of the tribunal. Ms. Chang, may I clarify that the proposal in this document is the creation of a post equal to a CFI judge with the legislative support. The actual person holding the post, that is the post of the president, will have to await for the recommendation of the Judicial Officers Recommendation Commission before the Chief Executive shall make the appointment. So what we're proposing is just a post. We don't have someone in mind in the proposal. And if the Recommendation Commission is of the view that an existing CFI judge is a better candidate to hold the post, they may make the recommendation accordingly. We are only proposing to create a post, to have an additional post to accommodate the workload, so that it will be considered together with the post related to the registrar and other supporting staff. Well, but that is not the impression I get. And if you say in this open meeting in the LegCo that that is the case, then I will accept this clarification from the administration. But I hope the administration will understand that a clear message should be disseminated in the judiciary. The duty of the president and the deputy president is very significant. If an unexperienced judge is asked to hear cases, then we will all be uncomfortable. I hope that you will send a clear message to the judiciary. Well, I would like to send a clear message to the administration and the judiciary that we don't want someone new to be dealing with such cases. We need an experienced, a relatively more senior and experienced judge who's got experience in dealing with commercial cases to hear cases in the tribunal. And under the circumstances, I will support your proposal. Anything to add? I will reflect members' view, and I would like to also say that in the tribunal, apart from the president, there are other judges as well, say a deputy president. And CFI judges will, by virtue of their appointment as CFI judge, be a member of the tribunal. So there will be a large pool of judges hearing cases related to the competition ordinance. Mr. Wong Ting Kwong, I accept Ms. Cheung's explanation. The DAB in principle support the administration's proposal. This will be conducive to the implementation of the competition ordinance. And in relation to the number of, I see that there are flexibilities in the number of members of the tribunal. Under the current plan, I'd like to ask, when will the judiciary come up with a set of subsidiary legislation? When will the subsidiary legislation be introduced to the LegCo for scrutiny? In relation to the rules and procedures and the practice and procedures, when will they be prescribed? Who is to take this question? In the setting of the competition tribunal, the timetable will tie in with the executive arm for the full implementation of the ordinance. Our current proposal, if endorsed by the LegCo for the creation of such judicial posts, part of the provisions of the related to the tribunal will come into operation on the 1st of August next year. When the president and deputy president are appointed, we will proceed at full steam to deal with the subsidiary legislation. Practice directions, procedures will be dealt with swiftly. And after all, we're talking about legislation. We will have to be very careful. We take reference from overseas jurisdictions where there are competition legislation, and we also take reference from similar rules and procedures in the court proceedings, and then we will conduct consultation before coming back to the LegCo. We hope that in about 2014 we will ask for an endorsement from the relevant panel before going to the Council, and this will be done by negative vetting. I would like to follow up on a question. When will they go to the establishment subcommittee in relation to this proposal? If we endorse it, well, if it is endorsed today, do they have a plan as to when it will go to this establishment subcommittee?
Yes, we will need to go to the establishment committee before we go to the financial committee, the finance committee. Do we have to come back to this panel after that? Well, actually, if we pass this recommendation today, then end of January 2013, we'll be going to, before we go to the established committee, we will also apply to the finance committee for this new position to be established. I have two questions to ask concerning this. For this sum, is it part of the sum that has been mentioned by the government concerning the operation of the competition ordinance? Is this part of the budgeted funds? And I also agree with Mr. Ronnie Tong, and that is there are different concerns from the public and from the business side, from the legal profession, etc., because this is completely new, this competition ordinance, and there are no precedents. And of course, we would want to know more about this ordinance as much as possible, and if there can be a judge appointed, whether in his previous private practice or in his time on the bench, if he had experience, that would be good. I think you can go back and consider that point. Secondly, timetable. Do you have a timetable as to when you would want to be able to successfully appoint these two judges, and also when will they start work? Well, first of all, is this part of the budget for the competition ordinance operation? Well, first of all, on the budget. When we were discussing competition ordinance, we have talked about the funds earmarked by the government at actually 80 million Hong Kong dollars. This is actually for the, this actually does not include the two positions that we have talked about, and also the tribunal in its operations in the future. For the tribunal's expenses and the positions expenses, perhaps my colleagues will be able to supplement. Ms. Zhang again. Well, in order to set up this tribunal, it would be 22 million annually in terms of operations, and 9 million would be operations expenses, and 3 million would be staff cost defrayment. And also there are one-off expenses as well. For example, in setting up the tribunal, we actually need certain devices and equipment to the tune of $2.6 million. And all these will be deposited into, will be part of the budget of the judiciary. Now, if we have the agreement of the LegCo, then in March we will have the Finance Committee's approval. Then we would have established these two positions. And then we will have the committee come up with nominations for the chief judge and also the assistant judge, the president as well as the assistant president. And then there will be appointments by the CE. And as mentioned, we would want to be able to complete all this work before the 1st of August. And as the ordinance come into enforcement, we would want to have completed our preparations for the enforcement of the ordinance. Are we all in agreement in support for this recommendation? Yes? I think we are mostly in support of this recommendation. And at a later date, the government will, at the Establishment Committee and the Finance Committee, submit the proposal and application. Thank you very much for coming to the meeting. Next, we will be going through the annual tariff reviews with the two power companies. Now, because we are early, well, let us rest for 5 minutes to wait